I think we're all now ready to resume. So James.
Well, good afternoon. I was going to turn to section 101(2) of the Scotland Act, which is the interpretation provision, where provisions of legislation might be read as being outside competence. That's on page 531 of the electronic bundle. And you'll see that it provides in sub 1, this section applies to any provision of an act of the Scottish Parliament or a bill for such act and so on, which could be read in such a way as to be outside competence. Such a provision is to be read as narrowly as is required for it to be within competence, if such a reading is possible and is to have effect accordingly. So that's the nature of the provision. Just by way of introduction, the Lord Advocate does not challenge the law officer's submission that the relevant provisions of sections 19, 20 and 21 of the UNCRC bill cannot be read down. The law officers who set out their case in this respect in paragraphs 115 to 118 of their case, and the Lord Advocate, see para 97 of his, disagree about whether the relevant provisions of sections 4 and 5 of the Charter Bill can be read down. And the Lord Advocate accepts that, at least to some extent, section 6 of the UNCRC bill would be outside competence were it not to be read down. The Lord Advocate submits that section 6 of the UNCRC bill can be read down. The law officers accept that it may be possible to read it down, but have included section 6 in the reference because it is far from clear whether that is so in the light of the provision of 101(2) and how far it can go. So the reference is really in the interest of legal clarity and certainty. Can I just start with the extent of the section 6 problem to be solved or not by section 101(2)? As we've seen, section 6 of the UNCRC bill makes it unlawful for a public authority to act in a way that is incompatible with the UNCRC requirements, page 245 in the electronics. And that provision, plainly on its face, has a very wide reach. The only bodies that are excluded from the scope of public authority are the Scottish Parliament itself and persons who are carrying out functions in connection with its proceedings. There is no limit on the functions of the public authorities to which section 6 applies. There is nothing in the bill that restricts the applicability of section 6 in accordance with any of the limits on the Scottish Parliament's legislative competence. It doesn't even have the save insofar as with incompetence provisions that one sees in the other provisions. And for that reason, no doubt, there is no dispute that section 6 is on its face outside the legislative competence of the Scottish Parliament to some extent. In the policy memorandum accompanying the bill, at paragraph 124, see page 327, it was accepted by the Scottish Government that the section would be outside legislative competence to apply section 6 to some bodies, and that to apply section 6 to some functions would modify the law on reserved matters, contrary to section 29(1)(c) and schedule 4, paragraph 2(1) of the Scotland Act. And the Lord Advocate's case repeats that concession on modification of the law on reserved matters, and the concession that section 6 cannot apply to the bodies listed in paragraph 3, sub 2 of part 3 of schedule 5. So it's the gap essentially between what it says and what it does that prompted the law officers to include section 6 in these references. And the concern is an obvious one, or a set of concerns are relatively obvious, the amount of work that section 1012 has to do to keep section 6 inside the Scottish Parliament's legislative competence. The lack of any specific suggestion on the part of the Scottish Government in the bill documents or the Lord Advocate in his case as to precisely how section 1012 should be applied to read down section 6. What words are to be read in? What is to be excised? And flowing from all of that, the lack of legal certainty and clarity that results, and the resultant confusion of those who might be subject to the duty or duties reading this provision on its face. It might be thought that until it is actually challenged and those points are clarified, section 6 will be likely to be applied in accordance with its natural meaning and its terms. But there may well be, if there are challenges, many a myriad challenges as to precisely what its limits are and how they work. It's very unsatisfactory indeed, we submit, that those sort of issues are being left to this sort of interpretive exercise. Since the law officers and the Lord Advocate agree that section 6 is on its face partly outside legislative competence, it's perhaps unnecessary to spend any time orally on the reasons why that is so. And it might be thought that to the extent that there is disagreement on the various reasons as to why that is so, that's effectively academic. But just to sketch and do no more orally, it's accepted by the Lord Advocate that it's outside legislative competence because if the language is taken at face value, as I indicated, it modifies the law on reserved matters, contrary to 29.2c and Schedule 4, Para 4.2. The law officers also say that it is outside legislative competence for two other reasons. Firstly, because it relates to reserved matters, contrary to section 29.2b, that is dealt with in detail in our case at paragraphs 91 to 94. And secondly, because it modifies the Scotland Act section 28 sub 7, contrary to section 29.2c and schedule 4 para 4.1. And that is dealt with, made my submissions on that already in our case at paragraphs 95 and 96. But as I say, to some extent, it matters not precisely in what respect it's outside competence. To the extent that it does matter, those are fully developed in the written case and probably better left there, to the extent I haven't already picked them up in my earlier submissions. I wanted therefore to focus principally on how the Scotland Act and this provision 1012 works. And the first point to pick up is a point not about 1012 at all, but about section 29 of the Scotland Act. And section 29 is at page 488 of the electronic bundle. And it provides, as you see there in sub 1, an act of the Scottish Parliament is not law so far as any provision of the act is outside legislative competence, the legislative competence of the Scottish Parliament. What the Lord Advocate says, or appears to say in the case, is that section 29 is, as he puts it, the quote principal way to read down a provision like section 6 that is outside the legislative competence of the Scottish Parliament on its face. That's paragraph 78 of his case. We respectfully submit that that cannot be right. Section 29 governs and clarifies the consequence of a provision being outside legislative competence. It is a nullity or, quote, not law. Section 1012, by contrast, fulfills an entirely distinct and prior function. It examines whether there is or is not a way of avoiding that consequence through the interpretive rule that is section 1012. So section 29 is not a read-down provision at all, or anything like it. it simply operates to describe, as I say, the consequence of a provision being outside, and confirms that severance can be applied in a suitable case. So section 29 does not help this exercise, we submit. So on section 1012, going to that as the interpretive game in town, we submit that section 1012 can be read and can be used to read down the scope of a general provision to keep it inside competence, where the provision can otherwise be read as also reaching outside competence. In other words, where the general words used are uncertain or ambiguous. But it is very difficult, we submit, to use it to interpret a provision in an Act of the Scottish Parliament or a bill, contrary to an ascertained intention of the Scottish Parliament revealed by the language it used or ordinary principles of interpretation, or contrary to that Act of the Scottish Parliament or bill's general thrust. And those controls are necessary, we submit, to ensure that the courts do not trespass in this context on the legislative powers that the Scotland Act has given to the Scottish Parliament, and to ensure that legal certainty is at least given the vestige of protection against the risk of draftsmen in effect ignoring the limits on legislative competence in what may be a difficult and complex area on the basis that it can all be sorted out later by the courts. And I wanted to make 4 short general points about 101 sub 2. First of all, we submit that the controls that I've just identified are consistent with the judicial decisions on section 101 and the equivalent provision in the Government of Wales Act, which is 154 sub 2, that are summarised in our case at paragraphs 103 to 107. That is 155 in the electronic. And I wanted in particular to draw your attention or to remind you of the way in which it was explained by Lord Newburgh in the Bylaws Bill case at para 64, which we quoted in paragraph 103 of our case on page 155. Not possible to read down if it would be, as he puts it, inconsistent with the plain words of the relevant section. In other words, no ambiguity. If you want that passage in the raw, in the authorities, it's at page 815. That's the first point. The second point is that the controls are also supported by the background materials relating to section 1012, indicating what the United Kingdom Parliament in its enactment and the explanatory notes in that regard are to be found at page 442. And what they indicate, we submit, is that it was intended to replicate the common law principle of efficacy. See in particular the final sentence of the paragraph under the heading General, about halfway down page 442. And you'll see the intention if you just track back to the end of the previous paragraph, halfway through that first full paragraph on page 442, it's intended to ensure that courts will not invalidate such legislation merely because it could be read in such a way as to make it outside competence, such as outside the legislative competence of the Parliament or the competence of the Scottish ministers, and so on. So that supports, we respectfully submit, some measure of ambiguity applying in effect where legislation could be read in one way or could be read in another, and there is therefore a range of meanings or approaches, as it were, and so you plump for the one that does the possible, that does the efficacious thing. The explanatory notes also indicate, without dealing with this expressly, but they certainly appear to proceed on the basis that there is room for a clear distinction between section 1012 on the one hand and section 3 of the HRA on the other. Well, of course, there's some degree of overlap in modelling. There's no suggestion in the explanatory notes that they were intended to operate in precisely the same way. And of course, we know from all the materials that I referred to earlier on that section 3 is a pretty muscular provision and was intended to be so, going far beyond the present rule of interpretation or of resolving ambiguities. It was put in the white paper that preceded section 3. See, for that purpose, paragraph 2.7 of the white paper preceding the HRA on page 3089. Nothing equivalent is found in the background materials to section 1012 of the Scotland Act. And we would add, for good measure, just in case the Lord Advocate is querying, Lord Sales, yes.
I was just wondering whether it might be said that part of the context against which section 101 falls to be read as compared with section 3 of the Human Rights Act is that, so far as the Human Rights Act is concerned, the Parliament was looking towards an area where there was a very developed body of case law, which, if you like, filled in to some degree what the obligations were going to be, which were being imported via the Human Rights Act. And you have section 2.1 making reference to that case law. Whereas I was wondering whether it might be said that there's a difference here, that insofar as you're looking to competence, that may depend on very unclear standards to be derived from the Act itself, on which there isn't any developed case law, at any rate, at the time when the Scotland Act was passed. Is there anything?
I think that, if I respectfully say so, I think that is a fair distinction. And what it does is to reinforce the idea that one shouldn't necessarily, and despite what we acknowledge is the obvious similarity of the use of the same adjective, one shouldn't necessarily assume that they're going to operate and were intended to operate in the same way.
Just to pursue that thought a little bit, I wonder whether it might be said that one construes, if you like, both statutes against the background of a rule of law paradigm. They're both legislation for a constitutional democracy subject to the rule of law. And in the case of the Human Rights Act, by virtue of the fact that you have this body of case law to which reference can be made, there is guidance that is potentially available from that. Whereas I wonder whether it might be said that in the context of the Scotland Act, there is a particular onus on the Scottish Parliament to lay down clear rules of law in its own legislation, which would satisfy that general rule of law requirement in a way which doesn't appear to be so easy to do in the context of the Scotland Act, by contrast with the Human Rights Act.
My lord, yes, and I confess it wasn't a thought that had occurred to me before you put it to me, but I see real force in it. I may respectfully say so. I mean, it's essentially about it's essentially about regulating the art of the constitutionally possible. And if you've got a set of guidelines which indicate where lines should be drawn, that's one thing, and if you haven't, that's quite another. And somehow
I'm so sorry.
One's got to confront the fact that the same adjective is used, and it's used in acts that are passed in the same year at least. So there's to some extent a modelling on it, but both provisions have to be construed in their particular context. And I suppose the other thing to bear in mind, just to take that thought on a bit, it may not be quite the same thought as my Lord Sales has just put to me, but one also doesn't see in the Scotland Act, and if one's thinking in terms constitutional, one doesn't see any equivalent of Section 4 of the HRA, which is the flip side to Section 3, and to some extent indicates that the intended breadth of the Section 3 operation. Not merely does it have clear rules, but you've got the legislative alternative. You've got the provision that allows you under the Human Rights Act, at least, to make declarations of incompatibility and so on. That finds no analogue in the context of 1012. But essentially, I agree with my lord that control over the art of the possible is important.
Could I, in that context, mention one other thought that occurred to me reading into this case? That in the Belmarsh case, there was an effort by the government to invite the courts, in effect, to read down one of the derogation instruments. And Lord Bingham, at paragraph 33, said that in the context of individual liberty in that case, it wasn't acceptable to find limitations on what seemed to be general worth just by implication and concession by the government. And I wondered whether that was, if you like, indicative of the importance of rule of law in this context, where you've got a legislature purporting to lay down rules, that there's some onus on it deriving from its responsibility to promote the rule of law, to be reasonably definite in terms of what legal rules it is promulgating, rather than leaving matters to the courts to sort out to an excessive degree later on. Obviously, they have to sort things out to a degree where there's an issue of interpretation, but that there's a limit to how far they should go. Anyway, can I just leave that with you?
I'm not sure whether Belmarsh is in the bundles, but if it isn't, we can make sure that you have copies of that overnight. And
well, I apologise if it's a wild goose chase, but it did occur to me as I was reading him. Thank you.
With respect, it doesn't sound like a wild goose chase at all. But it may there may be a variety of considerations which underpinned, from recollection, that reasoning and conclusion of Lord Bingham. But rule of law is one thing, the human rights paradigm is another. But the other element, perhaps it's inherent in the rule of law as a concept anyway, but the other element that is to be borne in mind is the idea of legal certainty, and where the sorts of decisions that need to be taken about the limits are to be taken and should be taken. There's a constitutional angle to that, at least. I mean, some of the lines that one can argue about in relation to Section 1012 and its application as a vehicle for controlling, for example, Section 6 of the UNCRC bill, some of the lines are inherently deeply uncertain about where and how that might be done. It could be done in a variety of different ways. And to some extent, there is at least a reflection back into legal certainty and a reflection of the sort of thoughts that my Lord has just been putting to me. Constitutionally, it might be thought to be a great deal better, not just simply to leave these difficult lines to be drawn by the courts in some place, but actually to be, particularly when you're dealing with a subject matter as broad as Section 6, that those fundamentally can and should be drawn by the relevant body with a constitutional remit to draw them, which isn't the courts in the context of this Act. It is the Scottish Parliament. And it's not appropriate to just abandon that exercise and say to the court, sort it out.
You took us this morning to the passage in my judgment in AXA, and Lord Hope said something similar in his judgment, to the effect that the Scotland Act has to be construed as having been intended for a liberal democracy governed in accordance with the rule of law. And we had this type of problem in the Christian Institute case, where the legislation dealing with, it had all sorts of provisions in it to do with the sharing of information and about children. And there had been no attempt to relate those provisions to the Data Protection Act. And it was apparent to the court that the legislation could not be taken at face value. You would have to read it, as we put it, with the legislation and that legislation in one hand, the Data Protection Act in the other hand, and try to understand how the two interrelated.
Yeah.
And we said that that was not in accordance with the rule of law. Sorry, it was not in accordance with the law for the purposes of Article 8, because there was an Article 8 challenge there. And that was the basis on which the compatibility challenge succeeded, the devolution challenge succeeded in that case. Now, here, I suppose one could equally foresee the possibility that there might be legislation to which Article 8 was relevant, or other articles, which would give rise to a similar problem. But the more basic point may be the one that you get from the AXA case.
Well, yes, and I think the point that you were making in relation to Christian Institute is a point which we had the temerity to remind you of in paragraph 107 of our case, where we drew specific attention to the fact that the court concluded, I think the paragraph you had in mind was at 106 of Christian Institute. I've got a reference, which is on page 2174 in the electronic bundle, effectively saying that 1012 could not be used to remedy that deficiency. Of course, the positions are different, but they have the similarities that we've been discussing, whether you call them constitutional, whether you call them rule of law, whether you call them legal certainty, whether you approach them through the prism of trying to work out who constitutionally is the right person to draw those lines, or the right body, it matters not, perhaps. Is that the passage my Lord had in mind at 106? Yeah.
So James, just before we move on, I was just wondering whether it might be said that the two thoughts, in a sense, go together. Obviously, there's the wider idea of the UK Parliament legislating generally for liberal democracy subject to the rule of law, but also in the particular context we're dealing with here, where the convention rights are themselves written in to limit the competence of the Scottish Parliament. Yeah. And convention rights, as my Lord Reid has just pointed out, import their own requirements of clarity in the law. Whether those two features, if you like, run in tandem in relation to the Scotland Act to perhaps give emphasis to the point that you're making.
Yes, my Lord, I see the force of that entirely. I mean, but they all of these points, with respect, they all point in the same direction, which is that although the same adjective is used, there is a real burden on the relevant constitutional actor to specify properly and with sufficient specificity to avoid all of these rule of law and legal certainty problems, to specify clearly how things can and should work, particularly in an area where you end up with judgments about, you end up having to try and work out where the lines truly are. So we respectfully submit that is the right approach. I see entirely the idea of the lines of thought intersecting in that way, but without wishing to risk, as it were, creating a tension with that line, there has at least been some consideration in the past by the Supreme Court as to whether or not sections 3 of the HRA and 1012 should be taken, although of course there are similarities and we've been discussing them at the point of intersection, but whether they should be taken as operating necessarily in precisely the same way. To put it no higher than this, that at least doesn't appear to have been the assumption of the Supreme Court, which treated the issues of section 3 followed by 1012 as being at least analytically separate exercises. One sees that line of thinking in the Salverson case at paragraph 46, page 2005, and one sees the same approach in DS and Her Majesty's Advocate at paragraphs 21 to 24. That's page 722 in the bundle. So we put down a marker that it is not to be assumed that section 1012 and 3 necessarily operate in the same way, although it is entirely right that for all of the reasons we've been discussing, there may be overlap between them, but that doesn't necessarily help the Lord Advocate, because to the extent that there is overlap, it's an overlap which suggests that specificity is properly required, not least to give proper effect to all of this. So that's what we say about the general approach in terms of application and effect of 101(2). And then so far as section 6 is concerned, we do, well, it'll be for you, you hardly need submissions of it. I mean, my short submission is that section 6 is just simply leaves lots of these issues hanging. There's a question mark about how far it's outside legislative competence, or would be. No attempt is made to draw any of the lines that should properly be drawn in order to create that degree of specificity. It's one thing to say that generally we intend all this to keep us within competence. It's quite another to inform the public and those who are governed by this provision. Quite another thing to tell them how it's actually meant to work. And there is no attempt to do that at all. There's also, we would note, in the Lord Advocate's submissions, no specificity whatever on how the wording of section 6 is to be read or interpreted, quote, narrowly. I'm just not sure what words are to be interpolated or what words are to be struck out. There's no linguistic suggestion of how it could or should be read so as to preserve the express exclusion and yet add a series of further exclusions consistently with the thrust of the legislation. It's difficult to see how the court could even start doing that exercise in the absence of any form of suggestion as to how the provision could be read as a matter of interpretation. And the same points in effect apply for the reasons given in our case at 115 to 118 to sections 4.1a and 5.1 of the Charter. We respectfully submit that that is a challenge for the Lord Advocate to take up, because at the moment we simply don't understand how it is said that a provision of this generality, which is accepted to be in significant part outside competence, is in fact designed to work even at the policy level in terms of drawing those lines. And obviously, the more complicated they are, the less likely it is that you can solve it by interpretation. But B, and also, what words it is said should be added or deleted from the section as a matter of interpretation to make those things. So that's our case on 1012. And how it applies in the context of the only really relevant provision here, which is section 6. Well, just on sections 4.1 capital A and 5.1 of the Charter Bill, they apply the section 4 and 5 power and duty to an act. Read in context and with the application of the interpretive rules in Scottish law, the plain meaning of that word includes Act of the UK Parliament. In addition, where the bill wishes to differentiate between acts of the Scottish Parliament and acts of the Westminster Parliament, it does so expressly. See section 2.2b on page 90. And it's obvious, we submit from the background materials, that the plain meaning gives effect to the Scottish Parliament's clear intention. And any other interpretation would frustrate that intention. That's the additional point in relation to those sections. But my lords, those are my submissions on 1012. and indeed on the competence issues which I dealt with before the short adjournment. So unless there are further questions for me or I can seek to assist further, those are my submissions.
Thank you very much, Sir James. So in that case, we can turn to Mr. Muir.
Thank you, my lords. I hope that the court can hear me sufficiently.
Yes, thank you.
Thank you. My lords, I'd like to begin, if I may, by looking briefly at the constitutional position of the Scotland Act, and then to look at parliamentary sovereignty and section 28(7). It does appear that much of this material about the constitutional position of the Scottish Parliament is not, I think, in debate between us, but it is important that the court appreciates, of course, that the Scotland Act creates a new polity with a Scottish Parliament as the primary lawmaker with plenary powers, as this court explained in the case of AXA. And the UK Parliament intended that and made that clear in section 28 of the Scotland Act, which of course doesn't provide simply decision-making powers to a popular, to a democratically elected parliament, but allows it to make laws. And in my submission, a central feature of the UK government's submissions appears to equate the Scottish Parliament with a decision maker under an Act of Parliament, and fails to give any due regard to the constitutional position of a newly created democratically elected Parliament with the power to make laws, which have, as this court said in AXA, the power of legislative force in Scotland. Now, my lords, the references to that, and we may not need to turn it up just now, but in AXA, my Lord Reid covers that point at page 790 in the bundle. This is at paragraph 138. And I can just give my lords the key words from this. At paragraph 138, my lord noted that the Scottish Parliament is not a sovereign parliament in the sense that Westminster can be described as sovereign. Its powers were conferred by an Act of Parliament and therefore are limited. And of course, that is correct. But within its sphere, within legislative competence, the Scottish Parliament, of course, has its laws have the full force of any statute within the United Kingdom. My lord, also at 142 speaks about judicial review, and as my lord says at 142, judicial review under the common law is based upon an understanding of the respective constitutional responsibilities of public authorities and the courts. And the simple point about acts of the Scottish Parliament, of course, is that they are subject to judicial review, but they are subject to review by the courts because of the statutory provisions in the Scotland Act. But at 145, in the, I think it's the fourth line of that paragraph, my lord said this: the purpose of the Scotland Act, as stated in its long title, was the establishment of a Scottish Parliament and administration and other changes to the government of Scotland. It established a democratically elected legislature having the power to make laws to be known as acts of the Scottish Parliament. And of course, the nomenclature is important. Such laws require to be made following procedures designed to ensure democratic scrutiny, some aspects of which are prescribed by the Act. They also require royal assent. They can amend or repeal acts of the United Kingdom Parliament, so far as applying to Scotland. And pausing there, of course, it's evident that they can do so expressly. They may do so, as I think the learned friend noted, they can do so impliedly. And as my lord at 146 goes on to say, its power to legislate is as ample as it could possibly be. And at the end of that paragraph, the Act leaves it to the Scottish Parliament itself, as a democratically elected legislature, to determine its own policy goals. It has to decide for itself the purposes for which its legislative powers should be used, and the political and other considerations which are relevant to its exercise of those powers. And of course, the context of this was the question of judicial review of acts of the Scottish Parliament. And the reason that my Lord reached the conclusion at 147 is explained there in the third line. Since its powers, the Parliament's powers, are plenary, they do not require to be exercised for any specific purpose or with regard to any specific considerations. It follows that grounds of review developed in relation to administrative bodies, which have been given limited powers for identifiable purposes, and which are designed to prevent such bodies from exceeding their powers or using them for an improper purpose, or being influenced by irrelevant considerations, generally have no purchase in such circumstances and cannot be applied. As a general rule and subject to the qualification, which I shall mention shortly, its decisions as to how to exercise its lawmaking powers require no justification in law other than the will of the Parliament. It is in principle accountable for the exercise of its powers within the limits set by section 29(2) to the electorate rather than to the courts. And my lords, the point about reminding us of that is to distinguish the position with that set out in the authorities which are cited by the UK law officers, namely Britnell, which is at tab 33 at page 1264, and the Public Law Project case, which is at tab 6 at page 822. It is said that these demonstrate, for example, that a decision-making power has to be interpreted in a restricted manner if there is any uncertainty. But of course, the point that I take from these cases is that in each of them, the court was upholding the supremacy of Parliament over the executive. And in each of those cases, powers had been specific powers for identifiable purposes that had been conferred by Parliament on the executive branch. And in my submission, it's a fundamental fallacy to seek to equate a democratically elected Parliament, which Parliament itself in Westminster has given the power to make laws. It's a fallacy to equate that Parliament, at least for the purpose of this argument, with the executive in the Public Law Project, Britnell, and indeed similarly the dictum from the Pearson case in 1997. And I think if we can look at the Public Law Project as...
Mr. Muir, can I just ask you something before we move on from AXA? Reading these paragraphs from Lord Reed's judgment, might it not be said that he's identifying the core point about the authority of the Scottish Parliament as being based in its exercise of its democratic authority in making decisions for itself? And I was wondering whether that was rather in tension with what seems to be happening in this case, where the substantive decisions about the nature of the particular legal obligations on Sir James's argument has been delegated down to the courts, which obviously are not a democratic institution at all and don't exercise that authority. I wondered if you had anything to say about that.
Well, indeed, I do, and it's really this, that when parliaments come to incorporate human rights instruments, and it goes back to the point I think that my Lord Sales made in discussion a little earlier this afternoon with my learned friend, but when it comes to incorporating human rights instruments and the language that's included in the articles of such instruments, one matter for a lawmaking parliament to consider is how best at that stage of enactment of incorporation into domestic law, it's possible or desirable to specify the specific effects of those articles on the existing statute book. Now, the approach taken in the Human Rights Act in 1998 was obviously not to go through the statute book piece by piece and to amend, but to incorporate specific articles. And as my Lord Sales pointed out, it had the advantage in that case of a certain body of case law. But it's fair to say that even that case law at the time was regarded as unclear on certain aspects, and indeed it continues to be, although we now have the benefit of more than 2 decades of judgments from our own domestic courts on them. But one can take, I think, too far the suggestion that the Human Rights Act was somehow in an entirely separate category because of the fact that there is a European Court of Human Rights. In my submission, the same difficulties of analysis and compatibility can arise and have arisen in the last 20 years in respect of articles of the Human Rights Convention, just as no doubt they will in respect of the UN Convention on the Rights of the Child. So I accept what my Lord says, but only up to a point, and I don't think that it cannot prevent a Parliament from taking a policy decision to incorporate in a particular manner. And of course, one of the things that I'll take the court to is the policy memorandum, which explains the approach that was taken and indeed why the approach was taken to incorporation in the case of the UNCRC.
Yes, thank you.
My Lords, I was going to look very briefly at the Public Law Project just to bring up the specific issue of the distinction that I say has to be made between these cases and the case that is before this court. The head note on page 822 reminds us that the judgment of this court in the Public Law Project was taken in order to uphold the supremacy of Parliament over the executive and not over a democratically elected Parliament. But the facts, as I'm sure the Lords are well aware, concerned the exercise of power under the Legal Aid Sentencing and Punishment of Offenders Act, LASPO, as it said, which was given to the then Lord Chancellor to amend schedules in the 2013 Act. And that's the background for the discussion at the paragraphs 23 and onwards about subordinate legislation and the way in which power has to be read restrictively. So at paragraph 23 on page 841, we see that it's dealing with subordinate legislation, and it's also dealing with judicial review on common law grounds. So firstly, it's a distinct case because we know that acts of the Scottish Parliament are not reviewable on traditional common law grounds of judicial review. So the courts don't have an inherent power in that sense to review acts of the Scottish Parliament. So those, essentially, it's the paragraphs from 23 down to 28, the bottom of page 841. So in my submission, effectively the 3 cases, the Pearson case, the Britnell case, and the Public Law Project case, are all ones dealing with a quite separate constitutional question. And the matter for this court, and it's an important one in my submission, is whether it's appropriate to read across that authority, which, as I say, is dealing with the supremacy of Parliament over the executive, and with judicial review on common law grounds of decisions taken by the executive, whether those dicta are applicable when construing the Scotland Act and the position in constitutional terms of the democratically elected Parliament. and we've explained in our case, and I've just explained in this submission why in my submission that's not the case. And again, the case of Pearson, again, I think it's Lord Brown Wilkinson's speech, which speaks of a power in general terms conferred by Parliament not being taken to authorise the doing of acts which adversely affect basic principles. Well, again, that's dealing with a power conferred upon the executive. And of course, my primary submission about the basic principles of the Constitution are that they have changed in the important sense since Pearson was decided in 1997, in the sense that there is now a body established by law, the Scottish Parliament, which does have the power to repeal and to amend acts of the Westminster Parliament. So that is a change in the constitutional paradigm that's made by the Scotland Act, and indeed by the Government of Wales Act, particularly as it now operates. And my submission, therefore, within legislative competence at least, acts of the Scottish Parliament cannot be regarded as hierarchically inferior to acts of the Westminster Parliament, because within legislative competence, both effectively have supremacy in the legal system in Scotland. And of course, I accept entirely that the United Kingdom Parliament may choose to amend or repeal or overwrite acts of the Scottish Parliament. That would involve a departure from the convention now written into section 28, subsection 8 of the Scotland Act, which specifies that the UK Parliament would not normally legislate in respect of matters that are not reserved without the consent of the Scottish Parliament. But nevertheless, that remains an option. And of course, we know that Parliament can protect UK acts against further modification by adding provisions to the list of protected enactments in Schedule 4. But the key point, as I say, is that the Constitution has changed, and there are now institutions within our Constitution that can amend, repeal, expressly or impliedly, acts of Parliament. And that's the important background against which the issues in this reference in my submission fall to be dealt with. I should also say, in terms of the constitutional role of this court, that in terms of a Section 33 reference, my lords the three lords who were present in the continuity bill case will recall that in that case there was some discussion of issues of legal certainty which had been raised as grounds for review of the continuity bill. And the court addressed this in the continuity bill judgment on page 870, paragraph 86. And essentially, at the opening of that paragraph on page 870 in the electronic bundle, the court finds that the residual challenge based on the rule of law is with respect misconceived. The principles of legal certainty and legality, when applied to the competence of the Scottish Parliament, operate within the statutory framework of the Scotland Act. The rule of law in relation to the legislative competence of the Scottish Parliament is maintained through the operation of Section 29 and Schedules 4 and 5 to the Scotland Act. And the scrutiny by this court under Section 33 of that Act, i.e. in a reference, relates to the application of those principles. That scrutiny involves an assessment whether legislation by the Scottish Parliament complies with the limitations imposed by Section 29. As we've stated, there is nothing legally uncertain or contrary to the rule of law about the enactment of legislation by both the UK Parliament and the Scottish Parliament, provided they don't conflict. And the court concludes thus: the remit of this court under Section 33 to scrutinise bills of the Scottish Parliament does not extend to addressing arguments which are either complaints about the quality of the drafting of a bill or seek to raise uncertainties about the application of the bill's provisions in future circumstances, which may or may not arise, and which, should they occur, may require amending legislation. In our view, the Lord Advocate is correct in his submission that the possibility of the need to amend legislation to take account of changed future circumstances, that was the specific point in that case, does not alter the competence of the legislation now. Now, I noticed my Lord Stevens.
Sorry,
yes.
I thought that Sir James's point about certainty arose in the context of section 101, subsection 2, namely that a court shouldn't construe something if it's going to end up lacking certainty, which is a slightly different point from the Scottish Parliament having competence to pass legislation itself, which is uncertain. If you're asking the courts to intervene, then the courts will only intervene if you can achieve certainty or something approximating to certainty. So I was just wondering why we're being referred to this point, if I understand Sir James correctly.
Well, my understanding was that that was the an issue taken about legal certainty in the application of section 101. I had understood his submission on legal certainty to go wider than that. And certainly in his case, the UK law officers appear to take a wider point about legal certainty and the provisions of the bill. So my respectful submission, it is relevant to remind the court of that passage. But I will come back to the question of section 101. I entirely accept that I need to address that.
Can I tempt you to do it now? But why should a court exercise the powers under section 101, subsection 2, if it doesn't achieve certainty or something approximating?
Well, first of all, I don't understand that that the court cannot achieve certainty. After all, what is being asked in the present case is, in my respectful submission, really no different from the way in which section 101 has been applied in previous authorities. And I can give my lords the examples of that. For example, there are, I think, 3 cases which we have produced in the bundle, and I can find the right part of our case. I'll give my lords the paragraph reference. It's on page 208 of the electronic bundle, at paragraph 82 of the case for the Lord Advocate, and it's dealing with essentially 3 key cases, and I can take my lords quickly to 2 of them, which dealt with how section 101 would be applied. The first is the Welsh bylaws case, which is at page 814 in, I think, tab 5 of the electronic bundle. The report begins at page 800, but Lord Hope and Lord Newburgh both considered this. The court will perhaps recall that in that case, there was a question about the extent to which the Assembly had power to make a provision that would allow changes to the inclusion of certain bylaws in it was section 9 of the bill that was under review, and the question was whether it was overly broad, and Lord Hope looked at the point at section 60. Sorry, Lord Newburgh looked at it at paragraph 64, having come to the conclusion on section 9 of the bill in paragraph 60 to 63. And at 63, he says, although it's perfectly true, there are no express words in section 9 which limit its scope in this way. I'm satisfied that it does have such limited effect. That's because of the simple legal principle identified by Lord Reed, embodied in the Latin maxim nemo dat quod non habet. Given that the jurisdiction of the Assembly is limited to removing or delegating the power to remove functions of ministers of the Crown when the removal satisfies the requirements of paragraph 6.1b, the Assembly cannot confer a wider power on Welsh ministers. Accordingly, the wide words of section 9 must be read as being circumscribed in their scope so as to render the section valid. So, my lords, there were no express words in the section under contemplation in that case, which limited its scope, but nevertheless, they were read as being circumscribed in order to keep the provision as valid. And on paragraph 64, Lord Neuberger says the same conclusion can be arrived by invoking section 154, subsection 2 of the 206 Act, which is the equivalent of section 101(2) in the Scotland Act. And he says it would not be permissible to invoke that statutory provision if it was inconsistent with the plain words of section 9. However, it would, in my view, be permissible to invoke it to limit the apparently unlimited and general effect of that briefly expressed section. Such an interpretation is consistent with the thrust of a bill as a whole, and it does not conflict with any other provision in the bill. And that point is reinforced by the fact that all currently scheduled enactments satisfy one or other of the requirements. And just for reference, I can give my lords, it's paragraph 84 on page 818, page 818 of the bundle, where Lord Hope reaches the same conclusion, saying that section 9 falls to be read as narrowly as is required for it to be within competence, if such a reading is possible, and to have effect accordingly. That can be done, said Lord Hope, by reading it in a way that brings it within the exception in paragraph 6.1b of part 3 of schedule 7. So effectively, both justices take the same view. Yes, my Lord Sales.
Yeah, I'm just looking again at paragraph 64, page 815. Might it not be said that Lord Neuberger's formulation there indicates that he thought section 101 in its context had a different application from section 3 of the Human Rights Act? Because he says that it wouldn't be permissible to use section 101 if the statutory provision was if that was inconsistent with the plain words of section 9. But where you're dealing with section 3 of the Human Rights Act, that power can be used where it said that the human rights compatibility issue involves incompatibility with the ordinary plain words of the section, which is to which section 3 is being applied.
It's a question in each case, I think, my lord, of deciding what the term "as far as possible" means, and certainly they're regarded. In my submission, they were, I think, got royal assent within 10 days of each other. These two bills, at the end of 1998, and the formulation is effectively the same. It refers to the insofar as possible, and it refers to both reading and giving effect. And of course, in linguistic terms, I think the point had been made by Lord Neuberger at the previous paragraph that there were no express words in section 9 that limited it, and yet the limitation was possible to read in by application of section 154, subsection 2.
Yeah, I mean, I follow everything that you've just said. All that I was putting to you was that, doesn't it appear from the second sentence of paragraph 64 that Lord Neuberger was taking the application of section 101 and whatever the word possible means in that context to have a different import from the use of the same language in section 3 of the Human Rights Act, which very specifically does allow additional words to be read in which are contrary or inconsistent with the plain words of the statutory provision which is being construed.
Well, I think, my lord, I would accept that when it comes to reading in words, I think that it may be that the jurisprudence on section 3 provides a different format. But again, I think that's something which, and the use of section 3 in place of section 101(2) is something that Lord Hope explains in the DS case. I think paragraphs 21 to 23. But when it comes, I think, to the use of section 101 and section 154, certainly to date, the courts they haven't read matters in, but they have been willing to read clear words which don't, on their face, express a restriction. they've been happy to read them as excluding matters which are clearly outside of legislative competence, thus preserving the life of the provision and making clear what the ambit of the provision has to be read as. And of course, it goes back to the question of how bills in devolved legislatures are drafted, because it's not the practice at present, at least, and perhaps because of such cases as this case and the continuity bill case, it's not the draftsman's practice to write out the specific limitations that evidently apply to the legislative competence of the parliaments. And that's why one doesn't customarily, for example, find a provision that explains that that the Act only extends to Scotland, or that that acts don't list the bodies which are protected under, for example, Part 3 of Schedule 5 to the Scotland Act from being subject to acts of the Scottish Parliament.
Does this only apply to Scotland?
I'm referring, my lord, to the provision in Section 29 of the Scotland Act, which prevents the Scottish Parliament from making provision for a legal system beyond Scotland. It's the provision 29(2)(a), I think. Outside competence, so far as it would form part of the law of a country or territory other than Scotland, or confer or remove functions exercisable otherwise than in or as regards Scotland. Now,
so to take my example from earlier today, if we have an immigration appeal which starts in the first tier tribunal sitting in Glasgow, you would say that the UNCRC bill, well, if it became an act, would apply to it.
yes, it would.
If the appeal is then heard in England, Field House, does the bill continue to apply?
Yes, I think it would, my lord, yes.
So it's not confined to tribunals sitting in Scotland.
Well, if it's applying the Scottish statute book, then in my submission, the Act would apply, because
No, it's applying the immigration legislation, I dare say. But you say that the tribunal, the upper tribunal sitting in immigration appeal chamber, sitting in Field House, would have to apply the Scottish UNCRC legislation.
Well, if the matter is subject to Scots law, then
Well,
yes.
That's what I'm asking. I'm asking you what the jurisdictional scope of this legislation is. You want to think about that and give me the answer tomorrow?
I maybe need to check that precise point, but that's certainly my understanding. I will have that checked.
Yeah. And you might think about UK tribunals which sit only in England but exercise jurisdiction over Scotland, such as the IPT.
Yes, I noted that from this morning's discussion, my lord.
Yeah.
Well, I will have to come back to Section 6 and Section 101, but just in terms of the legal approach, I've taken my lords to the bylaws case, and I think the other case is the continuity bill case itself, which of course I think paragraph 77, and that's at page 869 in the bundle, tab 7. And that's at the top of page 869, dealing in this particular case with the provision in the Scottish Continuity Bill at that stage, which would have repealed as spent certain provisions of UK law, and the at 77, this court held that the power of the ministers in section 36(2) to make regulations to bring section 33, which brought into force that repeal of enactments, was restricted by the terms of section 33. And then on the fifth line of paragraph 77, the court said that if it were necessary in order to avoid a breach of paragraph 4.1 of Schedule 4 to the Scotland Act that protected provisions at that section. Section 101(2), which we've set out in paragraph 16 above, requires the court to read section 36(2) narrowly, so that the apparently general power of the Scottish ministers to bring into force provisions of the Scottish Bill can be exercised in relation to section 33 only when it is competent to do so. That is to say, in that particular case, once the UK has withdrawn from the EU, and the provisions to be repealed have indeed become spent. So again, it was reading the provision in such a way as to maintain its competence. So it's perhaps a more restricted illustration than the Welsh bylaws case. And then the third case that we cite at paragraph 82 of our case is Henderson against HMA. I won't turn that one up, but it was a matter of concession in that case that the provision in the Scottish Act should be restricted so that it didn't have any effect on firearms offences, which at that stage were reserved to the United Kingdom Parliament. And I think it's paragraph 10 in the judgment of the High Court of Justiciary, page 1951 to 1952. Yes, my lord. My Lord Sales.
Sorry, still puzzling over paragraph 77 of the Continuity Bill, page 869. Might it not be said that that is consistent with Sir James's submission that section 101(2) is concerned, in effect, to replicate the principle of efficacy in relation to Scottish acts of the Scottish Parliament? I mean, that particular paragraph doesn't seem to directly support your submission, does it? That section 101(2) must be read in precisely the same way as section 3 of the Human Rights Act.
Well, I don't say that it has to be read in precisely the same way, and of course the wording is specifically different in the sense that section 101, subsection 2, contains the word narrowly. Such a provision is to be read as narrowly as is required. So I don't suggest two are to be equated.
But what I'm putting to you is, would you accept that insofar as there is an indication in paragraph 77 that section 101(2) could be used in that case, that is an example of its use which is consistent with Sir James's submissions as to the ambit of that provision?
Well, I suppose it is, but equally in my submission, it's consistent with the previous use of it in the Welsh bylaws case and in the criminal case in Scotland at Henderson, because it's allowing one to read, albeit in the absence of express words, which suggest a narrow or potential limit to the interpretation. Section 101(2) has plainly been used in that manner to read and to explain the matters that are accepted precisely because of the legislative competence of the Scottish Parliament. And I've said, my lords, that it's something which has been founded upon by draftsmen. That's the case I've given in the notice. In the case, there's an example of a policy memorandum explaining that point in footnote 74, page 209, and I think it's in the appendix. And of course, the policy memoranda for the present bills specifically mention and indeed the explanatory notes also explain the use of section 101. So perhaps for good or ill, but in my submission for good, the meaning of section 101 as it's been applied by the courts has been reflected in the approach taken to drafting bills for the Scottish Parliament. And we see that, as I say, in the words of explanatory notes and policy memoranda, which are set out in the bundle, and I'll take my words to them. I should also say that I think Sir James took the court to the explanatory notes, which are for the beginning of the appendix. And I think if I can just give my lords the reference to also the notes on clauses. I think the explanatory notes for section 101 are at page 442 in the electronic bundle. The notes on clauses are the notes and clauses are a little further on in the appendix, but if the court looks further on at page 477, you will have the contemporaneous notes on clauses. And the distinction, I think we explained it in the footnote, but the explanatory notes were produced by the Scotland office in 2004, whereas the notes on clauses were produced and published in January of 1998, along with the Scotland bill itself. And page 477, the original version of section 101 is said to provide that the acts of the Scottish Parliament have been construed so far as possible so as to be within the legislative competence of the Scottish Parliament and to have effect accordingly. This is intended to ensure that the courts will, in cases of doubt, tend towards a stricter interpretation of the effect of ASPs, thus reducing the scope for practical problems arising in consequence of the declaration of an apparently valid ASP as ultra vires. And the section to which that note applies is found or clause, I should say, is found in page 471, a few pages earlier in the document. And it was originally clause 28.9 of the bill, but I think that provision is in the same terms as section 102, except that we now have the use of the term narrowly, which has been added. Well, my lords, yes, my lord Sales.
Very sorry, Mr. Muir. Just looking at the notes on clauses, page 476. I mean, really, I think it's an echo of the question I asked you about the Welsh bylaws case. This, as expressed, seems to be predicated on using section 101 as an aid to interpretation in the traditional sphere of aids to interpretation, where there is ambiguity or doubt about the meaning of a statutory provision. But that seems, if anything, deliberately to underline the contrast with Section 3 of the Human Rights Act, which very specifically is intended to apply where there isn't any doubt or ambiguity if you just take the statutory provision by itself.
Well, my lord, the provision of 101 obviously doesn't itself mention the question of ambiguity, nor I think do the cases that we've cited in our written case that I've been mentioning, the Welsh bylaws case, the continuity case, the Henderson case. And if one thinks about it in terms of the importance of maintaining in force are provisioned by a parliament which has made laws and has expressed its policy, including the meaning by approval at stage 1 and the policy memorandum from the government. My submission, there isn't a necessity for ambiguity to appear on the face, and that's one of the points in my submission, at least, that Lord Neuberger is mentioning in the Welsh bylaws case, when he says that there are no express words that suggest on the face of it that there is that there should be a narrow reading, or that there may be two readings of the section in the Welsh Assembly's bill in that case.
Right, but I mean, you've taken us to this explanatory note on clauses as a potential aid to interpretation, and I was just putting to you that the way in which it's formulated, where it seems to express the application of section 1012 as applicable in cases of doubt, might it not be said that that is much more redolent of looking to find either an ambiguity, which tends to be the traditional formula, or some serious doubt about the meaning of the statutory provision that has been enacted, rather than using it as some supervening, overarching interpretive power to enable the courts to go far outside what appears to have been the intention of the legislative body that passes the relevant provision.
Well, I think one of the difficulties with that is that, of course, we know that the Scottish Parliament has a range of limits on its legislative competence, and certainly the approach taken to date has not been to spell out all of those and to set out the consequences of those where they are plain on the face of the Scotland Act. And if that was to be the approach taken to section 1012, then in my submission, that may have serious consequences, not simply for the drafting of acts of the Scottish Parliament in the future, but also for the body of statute passed by the Parliament since it first sat. And it's not a point that's been taken, as I say, in the jurisprudence dealing with it. I accept the law officers are asking for guidance on section 101 in a way that perhaps this court has not previously been asked. But in my submission, given that we're talking about an elected parliament, given that we're talking about provisions which have been in some cases in force for many years, I think the use of the word narrowly in the provision, which obviously was a change from 28(9), my submission, that means that it is open to the court to look at the provision and to read it against what the Scotland Act says about the Scottish Parliament's powers, and then to clarify what its legal effect is.
Of course, in UK parliamentary drafting, it's not the case that every presumptive restriction on the extent of an act is spelled out in that drafting either. I just wonder whether it might be said that there are different forms of uncertainty or limits on statutory authority or normal statutory authority, which means that in some cases it's easier to say, well, the Parliament obviously intended that this limit should apply, and section 1012 helps to a degree with that, as opposed to much more wide-ranging uncertainty, about which complaint is made in this case. I mean, in the context of UK legislative drafting, it's not usual to spell out the geographical extent of an act, and it's not usual to spell out the temporal effect of an act. Often that is left to presumptions of parliamentary intention, isn't it?
Yes, indeed it is, and I mean, I think it's true that in this sense, 101 and section 3 are both looking at matters that can be, in some senses, easy to pin down, and in others considerably harder. And I think Lord Lord Roger makes that point about Section 3 in the Human Rights Act at 115, paragraph 115 in the Gaydan case at page 703, speaking about powers and duties being beyond the scope of legislation enacted by Parliament. And he said, if that's right, the answer to such questions can't be clear-cut, will involve matters of degree which can't be determined in the abstract, but only by considering the particular legislation and issue. And that's, I think, what courts have used Section 3 to do. All I'm saying in my submission is that in the context of a Parliament, just as the UK Parliament doesn't explain all of the limits, including geographical, in its texts, the Scottish Parliament's approach, certainly to date, has been to expect the reader to be aware of the legislative competence limits on the Parliament, and the courts have similarly approached matters on that footing.
Yes, thank you very much.
Now, my lords, I was introducing the submission by considering first the constitutional position and making the distinction between the Parliament and decision makers under devolved powers from an act of Parliament. It's also important, obviously, to make the point, as we do in our case, that in terms of legislative competence, the policy allocation is to the Scottish ministers. They have the the devolved competence in terms of policy, and there's no dispute, obviously, in this case, that protection of children's rights is within legislative competence as part of Scots civil law. Scots civil law is defined at page 537 in the bundle at section 126 4b of the Scotland Act, and therefore the policy choices in my submission are ones that have been made. One of the criticisms made in the UK law officers case is the suggestion that the Scottish Parliament has, in some sense, chosen to avoid hard policy choices and has not chosen to go through the statute book provision by provision. And I've made the submission that in many ways the approach taken by the Scottish Parliament is the appropriate one for an international convention of this sort on human rights. But also, of course, I say that the policy choices have been made, and they are evident in the policy memorandum, which the court has in the electronic bundle at page 293. And if I can take the Lords just to one or two paragraphs in this, because it also points out very clearly the approach that was explained to the Parliament, and that the Parliament, in passing the bill, agreed in respect of how the bill should approach its task of incorporating these rights and obligations into Scots law. I make the point, and again, it's not controversial, that the reservation of international relations at page 567 in Schedule 5 does not reserve observing and implementing international obligations of the sort set out in the UNCRC. But in explaining to the public and to the Parliament the approach taken in the bill, the policy memorandum explains at paragraph 7 on page 294 that the approach, 294 in the bundle, paragraph 7, the approach which the bill takes is maximalist. It will ensure that children's rights are protected, respected and fulfilled in Scotland to the maximum extent of the Scottish Parliament's powers. And then it refers to a proactive culture of everyday accountability. The point there is simply that the Scottish Parliament has power across the whole Scottish statute book. As we know, it can appeal, modify, amend acts of the UK Parliament, within legislative competence. And if the desire is there to have a consistent application of the articles in the schedule to the bill taken from the UNCRC, then the way to do that is to incorporate the articles in a single measure rather than in a series of different measures, some in Scotland and some at some future date through Westminster. So the policy approach, at least, is to be as maximalist as possible, and that's the result of a policy decision taken on the back of the Scottish Government's desire to increase the protection on children's rights, but also noting that the convention was ratified some 30 years ago by the UK and is a core international human rights treaty. The policy background explains at paragraph 26 on page 299 various statutes, mainly made since devolution, pages 299, 300 and 301, statutes which seek to give force in Scots law to some of the articles in the UNCRC. And then there was considerable discussion and consultation in Scotland about the possible options and various means by which the rights could be given legal force in Scots law. And certainly the consultation responses that the government received showed a strong desire for direct incorporation. And I think you see that at paragraph 33 on page 303. But the starting point.
Why are you taking us through this? What are we supposed to get out of this document?
Essentially two things, my lord. I'm taking it so that the court is aware of the options that were considered and the fact that the policy responsibility for it.
Is that of any relevance to us? We're concerned with the lawfulness of the bill actually passed by the Parliament. The policy background to it, I wouldn't have thought makes any difference.
Well, it makes a difference in this sense that it underscores, as I say, the constitutional position of the Scottish ministers as being responsible to this Parliament and accountable to it for its use of the devolved competence and the legislative competence of the institutions created under the Scotland Act. That's the constitutional background. And secondly, I take my lords to this to point out the purpose of the Section 6 duty, which is noted at paragraph 120 on page 326, because that's relevant to the UK law officer's challenge to Section 6. And the purpose of that duty is explained on page 326 as being to protect children's rights and to further the fulfilment of children's rights in Scotland. And I do that simply to make the point that that's the fundamental purpose of having a duty placed upon public authorities. I have to come to the submission on the extent to which the manner in which that's been put into the bill is within legislative competence. But it's important to be aware of what the intended purpose of that was and the reason that the Parliament passed the bill. I can leave the rest of that document, I think, for the court to look at. But just to be clear about the other references in this part of the electronic bundle, the explanatory notes follow after the policy memorandum, and again we get explanation of the key provisions, and I can give the references. It's in the explanatory notes at page 362 to 366 about sections 19, 20 and 21, and in respect of section 6, The explanatory notes are found at page 352. And the reason to take my lords to that is, again, to make the point at page 352 that the explanatory notes say this about the phrase public authority in section 6. The phrase public authority, when used in a provision of an act of the Scottish Parliament, cannot be read as extending to an authority if it would be outside the Parliament's legislative competence for the provision to extend to that authority. See the interpretation rule in section 101 of the Scotland Act 1998. The limits of the Parliament's legislative competence are set by section 29 of the Scotland Act 1998. In relation to both which bodies are captured and how those bodies exercise their functions, the duty applies only to the extent permissible within the limits of the Scottish Parliament's legislative competence. The bill makes specific provision in relation to the Scottish Parliament, and then it explains that. But it's important to understand where the draftsman began and where the basis upon which the bill was drafted. I appreciate this court is being asked to give judgment on the legal issues, but it is important, and I've mentioned the draftsman before and the way in which bills have previously been drafted, but it is important at least that this court is aware of the approach that is customarily taken by the draftsman, and that's, I think, best explained in that passage at paragraph 26 on page 352. My lords, before I come to look at the specific provisions of the bill and the impact they have or don't have on section 28(7, I need to say something about parliamentary sovereignty, because that is, as I read the UK law officers case, what in essence they say 28(7 is there to protect. Now, obviously, the scope and the nature of parliamentary sovereignty as time passes is ultimately a matter for this court to explain. I think in the Thoburn case, Lord Justice Laws said that parliamentary sovereignty is ultimately confided to the courts. Well, it is in the sense that the courts have to explain what it means in the particular context. But it's important to understand, as we've done by looking at AXA, that the understanding of parliamentary sovereignty does change over time, and in the sense that Parliament itself has created an institution which can and does amend or modify Acts of Parliament. Some of the earlier dicta about parliamentary sovereignty has to be read against the background of the 1998 devolution settlements. There's no doubt it's shared amongst us that parliamentary sovereignty is the fundamental basis of the Constitution in the United Kingdom, and this is obviously accepted. But what in my submission is at stake in this case is what Geoffrey Goldsworthy terms as the location of ultimate decision-making authority. That's what is ultimately at stake as I understand it. And that's the description of parliamentary sovereignty that Lord Bingham picks up in his book on the rule of law, again from Geoffrey Goldsworthy, part of whose book we've included in the bundle. So the location of ultimate decision-making authority. Now, obviously, we accept that the UK Parliament hasn't abandoned its sovereignty, and nothing in the Scotland Act or in an act of the Scottish Parliament can limit the legal power of Parliament to legislate for Scotland. But in my submission, section 28(7, which is in the bundle at page 487, that's the provision. This section does not affect the power of the Parliament of the United Kingdom to make laws for Scotland, is Firstly, obviously directing one to this section, section 28, which is the section which confers power to make laws, to be known as acts. But it's a section, it's a subsection, I should say, which is declaratory in the sense that it simply recognises what is a fundamental feature of parliamentary sovereignty, namely that it's the Westminster Parliament that is the ultimate location of decision-making authority within our constitution. It recognises that fundamental feature of parliamentary sovereignty. And the notes on clauses, I can give my lords the reference. It's at 473 for the provision, which at that stage was at clause 27, subsection 7 of the Scotland Bill, which is at page 470. The notes on clauses say it confirms the sovereignty of the United Kingdom Parliament by providing that the clause does not affect the power of the UK Parliament to make laws for Scotland. So, in a sense, it's not necessary, but and indeed it's been criticised by some as being inserted to assuage some people's fears. But of course, it has the undeniable clarification that it explains this is not a federal system in any way, and that's the point that this court made at paragraph 41 in its judgment in the Continuity Bill case at page 863 in the bundle. And of course 28.7, my lords, is one of several declaratory provisions. There's also 28.8 about the Scottish, about the UK Parliament not legislating normally with regard to devolved matters without the consent of the Scottish Parliament. It's again at page 487. And we now have the additional declaratory provisions at section 63, capital A, about the permanence of the Scottish Parliament and Scottish Government, which are in the bundle at page 527. So there are a series of provisions in the Scotland Act that are declaring constitutional reality or are making political commitments in a way which may not bind in law, but which obviously have a political impact. Now, parliamentary sovereignty, yes, my Lord Hodge.
Mr. Muir, you are equating 28.8 and 63A with 28.7, are you? Or are you recognizing that there's a very clear difference, that one is a statement of law, while the other two may be political commitments?
At 63A, my Lord.
You were talking about 28.8, the Sewell Convention.
Yes.
And you also mentioned 63A, that's the permanence of the institution, isn't it?
Yes, Lord, yes.
Yes. I mean, you're treating them as political commitments.
Well, I'm saying that that in terms of, I think it's the third subsection in 63 capital A, which says in view of that commitment, because section 3 capital A as a whole, it has to be read as a whole, and the second subsection explains to the reader what the purpose of it is. And it is simply to signify the commitment of the Parliament and Government of the United Kingdom to the Scottish Parliament and the Scottish Government. So on its face, perhaps it's explaining that it's a commitment by those institutions.
Yes, but 28.7 is a provision of a different nature.
Well, 28.7 underscores, well, it confirms, it recognises the fundamental feature of parliamentary sovereignty, and it does so in order to clarify that this settlement of lawmaking power on a new parliament is not to be regarded as in any way a federal system, so no power has been stripped from the United Kingdom Parliament. Therefore, it's legislative supremacy within our constitution remains.
Well, quite, but because if 28.7 wasn't there and you were left with 28.1, there might be doubt.
Well, in my submission, there wouldn't really be doubt, because a sovereign parliament cannot abandon its own sovereignty, and given the limits on legislative competence, it seems clear that there has to be a parliament that can legislate for Scotland in areas that are reserved. So I wouldn't say that the matter was of doubt myself.
Yeah, but it's not just a parliament legislating in areas that can be reserved. It's a parliament, the UK parliament can legislate in areas that are not reserved, but subject obviously to important conventions.
Yes, exactly.
Yes, thank you.
But of course, parliamentary sovereignty doesn't involve a claim that the UK Parliament can do anything that it wishes, of course, although in terms of lawmaking for Scotland, clearly it retains full power. But the Scotland Act, my lords, is an example of a statutory mechanism by which the Parliament in Westminster has created political and constitutional constraints on its power, and that's clear and is in a sense articulated by the provisions that we have at section 63 capital A. But Parliament, the Westminster Parliament, retains the power unqualified to make legislative provision for Scotland, and that in my submission is perfectly clear whether or not 28.7 is there, but it's the substance of Parliament's continuing legislative power for Scotland that in my submission is vital to parliamentary sovereignty. The fact that Parliament may need to express itself clearly doesn't involve a qualification of parliamentary sovereignty, and one can understand that if one looks at the circumstances of this court's decision in the continuity case at tab 7, because this is an important distinction between the provision that was being considered in the continuity bill and the provisions that we have before us today. The Lords will recall the cases at tab 7 and the section dealing with section 17 of the then Scottish bill is on page 862, and I want to take the court to that to respond to Sir James's submissions about what the court was saying in the continuity bill judgment. Section 17 of the bill is discussed at paragraphs 38 to 40, and the Lords have seen this already today, but if we look at paragraph 40 at the top of page 863, we get to the nub of the concern in that case. Subsection 1 having defined the ambit of section 17, subsections define some of the expressions employed. The operative provision is in subsection 2, which read thus: the subordinate legislation, to the extent that it contains devolved provision, is of no effect unless the consent of the Scottish ministers was obtained before it was made, confirmed, or approved. Now, what, in other words, sorry, my Lord Stevens has a question.
Couldn't you amend that, this case, and say the UK Parliament legislation has the extent that it contains devolved provisions is of an altered effect unless it is interpreted in accordance with the UNCRC?
Well, clearly there are two different points being raised by that in my submission. One is altered effect, and in the case of section 17 it was of no effect. And the point that was made in the continuity bill, as I read it, is that an external body was being inserted into the legislative process under the Act of Parliament. And this external body, the Scottish ministers, effectively had the power to veto the provision having any legal force and effect whatsoever. And therefore, Parliament did not have unqualified legislative power precisely because of that external body, the Scottish ministers. So it's two key points as I read the effect of section 17(2). Firstly, the external body being incorporated into the lawmaking power, and secondly, the fact that without the external body's approval, the provision is of no effect at all. And those, in my submission, were the key points that led the Supreme Court to hold that section 17 of the Scottish Continuity Bill was outside legislative competence. Because once it came in, then the effect of that section coming into force would be that the UK Parliament lacked an unqualified power to legislate. I don't think it matters that in that case we were looking at the consequence of the Act and its subordinate legislation, but effectively the complaint was that the unqualified power of Parliament was interfered with. By contrast, what's happening in, for example, the interpretive provision at section 19 is simply looking at the interpretation of provisions that are within the legislative competence of the Scottish Parliament. But crucially, they don't insert into the legislative process any external third party. And in terms of Parliament's unqualified lawmaking power going forward, there is nothing that can prevent the UK Parliament from choosing to legislate on any of these matters for Scotland, and it can do so using clear words. And those are the two key distinctions between what was before the court in the Continuity Bill case and what is before the court in the present case. The background that the Scottish Parliament can amend and can repeal Acts of Parliament tells us that it can equally condition the continuing legal force and effect of those Westminster Acts of Parliament, and indeed devolved parliaments have done so on many occasions since the devolved provisions came into force a little over 20 years ago. There are examples, for example, in the experience of Wales, there are examples given in the written intervention by the Counsel General for Wales. And there are similarly examples in the bundle of areas of law where an existing Westminster Act of Parliament continues in force, but has different effect or different application, precisely because the Scottish Parliament has chosen to modify its content and therefore the way that it functions. And that's true of, for example, acts in the sphere of children's rights in the Children's Scotland Act of 1995. It's equally true in terms of the Scottish application of provisions in the Environmental Protection Act of 1990. And again, example is in the bundle. So the clear distinction in my submission is that in order for the Scottish Parliament to be able consistently across the Scottish statute book, whether it's contained in an ASP or an act of the United Kingdom Parliament, for the Scottish Parliament to legislate consistently across all of that statute book, it is permissible under the Scotland Act for existing acts of Parliament to be conditioned in that manner so that they fit with policy decided by the Scottish Parliament. And that's why I say that the constitutional background of policy and of the broad lawmaking power conferred by Section 28 is relevant to understanding the stretch of the argument made by the UK law officers, because it would, in effect, it questions the approach taken to conditioning existing acts of the Westminster Parliament by modifying them either expressly or impliedly in the way that has been done over the last 20 years. And if I can bring that thought to a close in this way, the United Kingdom's Parliament still has the same legal power as it possessed before 1998, and its legislative power is undiminished, but it has conferred powers of a nature that have to permit the use of acts of Parliament in Scotland to make consistent the statute book across all of Scotland, whether it's Westminster or Edinburgh legislation. And the idea of consistency, of course, is one that's used on more than one occasion, I think, in the drafting of the Scotland Act itself. We see it in section 29(4), and it is, I think, important also when reading Schedule 4 to the Scotland Act and some of the provisions there, which I can take the court to tomorrow morning. But that really means that as we read the Scotland Act in constitutional terms, the provision by Westminster of this lawmaking power is designed to indicate that within legislative competence, obviously, there is an area of complete control and sovereignty similar, but derived from the one that Westminster has. And that's why such dicta as Lord Simon of Glasdale's comment in Picking, page 1260, have to be looked at carefully. That was the dictum about the courts having no power to declare enacted law to be invalid. Well, there plainly is power to do so in the sense of acts of the Scottish Parliament. Equally, in my submission, the Scottish Parliament has the power, just in interpretative terms, to ensure that the courts construe the entire statute book in a consistent manner. Otherwise, the incorporation of a human rights instrument, such as the UNCRC, becomes practically impossible for individual devolved nations to do. And if there is one thing that we've learned from the experience of devolution, it is that there can be much that each nation can learn from the other about how to incorporate conventions, about legal steps which may be tried in one nation of the UK and then taken up by others. And we've seen that both in Scotland with minimum alcohol pricing, which I think is now current in Wales and is now equally being suggested in England too. So that's what I wanted to say about sovereignty and about the Continuity Bill case. I notice it's 4 o'clock. What I would anticipate doing tomorrow morning is moving toward the specific provisions of the UNCRC bill 1920-21 explaining them and making submissions about them and about section 6.
Very well. Thank you, Mr. Muir. We'll adjourn then for the day and resume at 10:30 tomorrow morning.
I would like.